pleasant afternoon to each and everyone. Once again, good afternoon, Ma'am Shirley, and to my dear classmates. But before we move on to the most anticipated part of the discussion, I would like to ask everyone to bow down your head for the prayer through a audio-video presentation. So I welcome you all to Module 2, Lesson 1, the Indigenous Peoples' Rights Act. Since we are talking about Indigenous Peoples' Rights Act of 1997, or also called IPRA, what does IPRA recognize and the rights it guarantees? So the Indigenous Peoples' Rights Act, or IPRA, of 1997, apparently it was officially designated as Republic Act number 8371. It is a Philippine law that recognizes and promotes the rights of indigenous cultural communities and indigenous peoples in the Philippines. Presenting the four basic rights of indigenous people. First is the right to ancestral domains and lands. Second, the right to self-governance and empowerment. Third, the right to social justice and human rights. The fourth, the right to cultural integrity. So why is it important to recognize the rights of indigenous people? Yes, simply because indigenous peoples help protect our environment. They fight climate change and build resilience to natural disasters. Yet, their rights aren't always protected way back years ago. But then, for the information of all, indigenous peoples own and occupy world surface area. Actually, they safeguard 80% of the world's remaining biodiversity. Come to think of it. Despite such extensive diversity in indigenous communities throughout the world, all indigenous peoples have one thing in common. They share a history of injustice. Indigenous people have been killed, tortured, and enslaved. In many cases, they have been denied the right in participating into governing processes of the current state systems. Conquest and colonization have attempted to steal their dignity and identity as indigenous peoples, as well as the fundamental right of self-determination. That's why it is really need to recognize the rights of indigenous peoples. Moving forward, what is ancestral domain means? So ancestral domain refers to the lands, territories, and resources of indigenous peoples, particularly in the Asia-Pacific region. So, what is ancestral domain defined? So, according to Republic Act 8371, under Section 56, the term ancestral domain, as stated in the Indigenous Peoples' Rights Act, refers to all areas generally belong to indigenous cultural communities or ICCs and to indigenous peoples or IPs, comprising lands, inland waters, coastal areas, and natural resources therein, that is held under a claim of ownership, occupied process by ICCs and IPs by themselves through their ancestors, communally or individually since time immemorial, and continuously to the present except when interrupted by war, force majeure, or displacement by force, deceit, still or as a consequence of government projects in private individuals or corporations, and which are necessary to ensure their economic, social, and cultural welfare. Also, under Section 56, ancestral domain includes lands, forests, pasture land, residential, agricultural, and other lands individually owned, whether alienable and disposable or otherwise, hunting ground, burial grounds, worship areas, bodies of water, mineral and other natural resources, and lands which may no longer be exclusively occupied by ICCs or IPs, but from which they traditionally had access for their subsistence and traditional activities, particularly the home ranges of ICCs and IPs who are still nomadic and or shifting cultivators. So in short, as we can observe or as we've noticed, that the land is the most imperative asset of the ICCs and the IPs, and most of them establish their homes in forest areas, and they depend on the natural resources that surround them as it supplies their daily needs. And for examples, gathering of forest products, hunting, fishing, establishments of small gardens are their types of livelihood. Perhaps indigenous people consider their lands as sacred as it, as also shown by the rituals that are connected to it.
A pleasant day to each and everyone, and to all the indigenous people throughout the world. Without any further ado, let us proceed to Section 7. It is the right to ancestral domains. The rights of ownership and possession of ICC's IPs to ancestral domains shall be recognized and protected. Such rights shall include: the first one is the right of ownership. It is the right to claim ownership over lands, bodies of water, traditionally and actually occupied by ICC's IPs, sacred places, traditional hunting, and fishing grounds, and all improvements made by at any time within the domains. The second one is the right to develop lands and natural resources. This was subject to Section 56 hereof, right to develop, control, and use lands and territories traditionally occupied, owned, or used to manage and conserve natural resources within the territories and uphold the responsibilities for future generations. To benefit and share the profits from allocation and utilization of the natural resources found therein. The right to negotiate the terms of and conditions for the exploration of natural resources in the areas for the purpose of ensuring ecological, environmental protection and conservation measures pursuant to national and customary laws. The right to an informed and intelligent participation in the formulation and in the implementation of any project, government or private, that will affect or impact upon the ancestral domains, and to receive the fair compensation for any damages which they may sustain as a result of the project, and the right to effective measures by the government to prevent interference with alienation, encroachment upon these rights. So, without any further ado, let us proceed to the third rights, which is under the Section 7 of Republic Act 8371. The third one is the right to stay in the territories. The right to stay in the territory and not to be removed therefrom. No ICC's IPs will be relocated without their free and prior informed consent, nor through any means other than eminent domain. Where relocation is considered necessary as an exceptional measure, such relocation shall take place only with the free and prior informed consent of IP and ICCs, as what I have stated earlier concerned, and whenever possible, they shall be guaranteed the right to return to their ancestral domains as soon as the grounds for relocation cease to exist. And moreover, when such return is not possible, as determined by the agreement or through appropriate procedures, ICC's indigenous people shall be provided in all possible cases with lands of quality and legal status at least equal to that of the land previously occupied by them, suitable to provide for their present needs and future development. Persons thus relocated shall likewise be fully compensated for any resulting loss or injury. So the fourth one is the right in case of displacement. So when relocation were at the moment, they have the right of their displacement. So in case of displacement, of course, as the result of natural catastrophes, the state shall endeavor to resettle the displaced ICC's IPs in suitable areas where they can have temporary life support systems, provided that the displaced ICC of IPs shall have the right to return to their abandoned lands until such time that the normalcy and safety of such lands shall be determined, provided further that their ancestral domain cease to exist and normalcy and safety of their previous resettlements are not possible, displaced ICC and IPs shall enjoy security of tenure over lands to which they have been resettled, provided furthermore that basic services and livelihood shall be provided to them to ensure that their needs are adequately addressed. The fifth one under Section 7 is the right to regulate entry of migrants. These are the right to regulate the entry of migrant settlers and organization into the domain. So that was understandable from the word it's migrants. So the sixth one is they have the right to have a safe and clean air and also the water. For this purpose, the ICCs or the indigenous people shall have access to integrated system for the management of their inland waters and airspace. The seventh one is the right to claim parts of reservation. This is the right to claim parts of their ancestral domains which have been reserved for various purposes except those reserved and intended for common public welfare and service. And the last one under the Section 7, right to resolve conflict. It is the right to resolve land conflicts in accordance with customary laws of the area where the land is located, and only in default thereof shall be amicable settlement and to the courts of justice whenever necessary.
In a Section 5 Indigenous concept of ownership, it is sustained the view that ancestral domains and all resources found therein shall serve as immaterial basis of their cultural integrity. The indigenous concept of ownership generally holds that ancestral domains are the ICCs or the IPs, private but community property which is belong to the old generation and therefore cannot be sold or disposed or destroyed. It likewise covers sustained and traditional resource right. In a Section 5 of the Article 12 of the Constitution state that the subject of the provision of this Constitution and national development policies and programs shall protect the rights of indigenous cultural communities to their ancestral lands to ensure their economic, social, and cultural well-being. In the Section 13, the self-governance, it states that they recognize the inherent rights of ICCs or indigenous culture communities or IPs to self-governance and self-determination and respect the integrity of their values, practices, and institutions. Consequently, the state shall guarantee the right of ICCs or IPs to freely pursue their economic, social, and cultural development, and why it is important. The self-governance of IPs. The self-governance, it is important. It is the best used to keep you away from the age you develop habits or pattern of behaviors that eliminate the needs to use a massive amount of self-control in an emergency. That is extremely important because self-control is a finite resource and must be used wisely. And one of the example of self-governance is the role of the state, community, or other group by its member. An example of this is self-governance is what the colonial people fought for, the colonization, revolution, and the political independence in the autonomy. And we the people, the document says that the people of the Philippine state choose to create the government. We the people also explains that the people elect a representative to make laws. This is a form of self-governance. And the social justice also, and the human rights. What is the human rights and how we uphold this? In order to uphold this principle of social justice and remove some of the barriers that people face, we as a society need to ensure that the people are. Social justice is also about the working towards a more equality society. Part of this is ensuring that people are treated with dignity and respect by those with a public power. Also, the main goal of the human rights. However, human rights are not just a value. Human rights are a set of the law that set the rules on how the state should treat individuals. In the IP, social justice and human rights, it is have to equal protection and non-discrimination, and have the rights during the armed conflict, equal opportunities and treatment, basic services, a protection to women, children, and the youth, integrated social and education. So, in my conclusion, the IPRA or the Indigenous People Republic Act is one of the world's most advanced law with comes to the right of indigenous people. It clearly states that the lands and forests that they have traditionally used for their existence, as well as the resources under them, belong to the implementation of the law, which have been subverted by the powerful external interests that have exploited provision of the law, such as FPIC, or the traditional contradictions of the law, which other laws of simply use force to displace their indigenous people, which there comes into existence relatively progressive governance that puts in authority its support of indigenous people. Then IPRA will become an inviolable mechanism to preserve and advance the rights of interest. That's all. Thank you.
Good day, my name is Queen Martricia Pisilin, and I am the fourth reporter of our topic, and I will be discussing the fourth basic right of indigenous people, which is the rights of cultural integrity. So when we say cultural integrity, it is a kind of practice in which to protect the materials, the traditions, the culture, and as well as the knowledges that originates from a particular community or culture. So in other words, it is premised on the common ownership of the local people over the natural resources. So it is under the Republic Act 8371, also known as the IPRA, or the Indigenous People Rights Act of 1997, and it has 9 sections from section 29 to 37. So let's start discussing the section 29, which is the protection of indigenous culture, traditions, and institutions. So in this section, the state shall respect, recognize, and protect the right of ICCs or IPs to preserve and protect their culture, traditions, and institutions. And it shall consider these rights in the formulation and application of national plans and policies. So, let's move on to the section 30, which is the educational systems. So the state shall provide equal access to various cultural opportunities to the ICCs or IPs through the educational system, public or private cultural entities, scholarships, grants, and other incentives without prejudice to their right to establish and control their educational systems and institutions by providing education in their own language in a manner appropriate to their cultural methods of teaching and learning. So therefore, the indigenous children or youths shall have the rights to all levels and forms of education of the state. So in section 31, the recognition of cultural diversity, the state shall endeavor to have the dignity and diversity of the cultures, traditions, histories, and aspirations of the ICCs or IPs appropriately reflected in all forms of education, public information, and cultural educational exchange. Consequently, the state shall take effective measures in consultation with ICCs or IPs concerned to eliminate prejudice and discrimination and to promote tolerance, understanding, and good relations among ICCs or IPs and all segments of society. Furthermore, the government shall take effective measures to ensure that the state-owned media duly reflect indigenous cultural diversity. So the state shall likewise ensure the participation of appropriate indigenous leaders in schools, communities, and international cooperative undertakings like festivals, conferences, seminars, and workshops to promote and enhance their distinctive heritage and values. So in section 32, the community intellectual rights, the ICCs or IPs have the right to practice and revitalize their own cultural traditions and customs. And when we say revitalize, it is to strengthen their own culture and tradition and as well as customs. So the state shall preserve, protect, and develop the past, present, and future manifestations of their cultures, as well as the right to the restitution of cultural, intellectual, religious, and spiritual property taken without their free and prior informed consent or in violation of their laws, traditions, and customs. So, in section 33, it is the rights to religious, cultural sites, and ceremonies. So the ICCs or IPs shall have the right to manifest, practice, develop, and teach their spiritual and religious traditions, customs, and ceremonies. And also, they have the right to maintain, protect, and have access to their religious and cultural sites, and the right to use and control of ceremonial objects, and the right to the repatriation of human remains. Accordingly, the state shall take effective measures in cooperation with the ICCs or IPs concerned to ensure that the indigenous sacred places, including burial sites, will be preserved, respected, and protected. So, to achieve this purpose, it shall be unlawful to first, to explore, excavate, or make diggings or archaeological sites of the ICCs or IPs for the purpose of obtaining materials of cultural values without the free and prior informed consent. Second is to deface or remove or otherwise destroy artifacts which are of great importance to the ICCs or IPs for the preservation of their cultural heritage. So that's all for the section 30. Let's move on to the section 34. So it is the right to indigenous knowledge systems and practices and to develop own sciences and technologies. So the ICCs or IPs are entitled to the recognition of the full ownership and control and protection of their cultural and intellectual rights. So they shall have the right to special measures to control, develop, and protect their sciences, technologies, and cultural manifestations, including human and other genetic resources, seeds, including derivatives of these resources, traditional medicines and health practices, vital medicinal plants, animals and minerals, indigenous knowledge systems and practices, knowledge of the properties of fauna and flora, oral traditions, literature, designs, and even visual and performing arts. So they have the right to be recognized, and they have the right to show their practices, or to share their practices, as well as their sciences and technologies. So let's move on to the section 35, which is the access to biological and genetic resources. So access to biological and genetic resources and to indigenous knowledge related to the conservation, utilization, and enhancement of these resources shall be allowed within ancestral lands and domains of the ICCs or IPs only with the free and prior informed consent of such communities, obtained in accordance with customary laws of the concerned community. So in section 36, which is the sustainable agro-technical development, the state shall recognize the right of ICCs or IPs to a sustainable agro-technological development and shall formulate and implement programs of action for its effective implementation. So the state shall likewise promote the biogenetic and resource management systems among the ICCs or IPs and shall encourage cooperation among government agencies to ensure the successful sustainable development of ICCs or IPs. So for the last section, which is in section 37, and it is the funds for archaeological and historical sites. So the ICCs or IPs here shall have the right to receive from the national government all funds, especially earmarked or allocated for the management and preservation of their archaeological and historical sites and artifacts with the financial and technical support of the national government agency. So it is already understandable that the national government agencies will help them for their funds to their preservation of the archaeological and historical sites as well. So that's all for my part. I hope you learned something, and thank you.
And right now, I know you already know what is the IPRA and other subtopics related to that one. So right now, we're going to discuss who will implement the IPRA. So to answer that one, the one that will implement the IPRA is the National Commission on Indigenous Peoples, or what we know NCIP. So who is this NCIP? NCIP which shall be the primary government agency responsible for the formulation and implementation of policies, plans, and programs to promote and protect the rights and well-being of the IPs and the recognition of their ancestral domains as well as the rights. So in this one, in the NCIP, it has 7 commissioners who are all indigenous person. So if you would ask me why it is 7 commissioners, it is because the 7 commissioners are appointed specifically from each of the ethnographic areas of the Philippines or the ethnographic regions of the Philippines. And the second bullet, we are all appointed by the President. So the President shall appoint the 7 commissioners of the NCIP 90 days from the activity of this act. And the second one, the third one, they have 3-year terms. And means to say that NCIP shall hold office for a period of 3 years terms and may be reappointed for another term. And they present the 7 ethnographic regions in the Philippines, as what I have discussed earlier. They are gonna represent the 7 areas, 7 ethnographic areas of the Philippines. So if you're planning to be a part of the NCIP or the National Commissions of Indigenous People to help our valued Indigenous people, so these are the qualifications for that one. So, these are the qualification, venue, and compensation. The chairperson and the 6 commissioners must be a natural-born Filipino citizens. Okay, so they are also bona fide members of the IPs as certified by his or her tribe and experience in an ethnic affairs who have worked for at least 10 years with IP community and or any government agency involved in IP, at least 35 years of age at the time of appointment, and must be proven in honesty and integrity. So let's go now to the organizational structure of NCRP. So if you would see, that structure is only the summary of the NCIP and who's those people involved to it. So you can actually take time to see that one. And also we have attached the present people who's involved on the NCIP. So if you would see, there are 7 commissioners and there are people under them. So if you would see, there's a lot of them actually. So they are gonna represent the 7 ethnographic areas of the Philippines. So take time to read that one. So let's go now to the authority of the commission. So what is the authority of the commission? So the commission is like a legislative body. It can make rules to implement the IPRA. It is also like a court of justice. The commission can hear and rule on cases filed before quasi-judicial function, and the commission's decision is appealable to the Court of Appeals, the second highest court in the Philippines. So in this one, the commission also shall have the authority, like the legislative body. They have the authority to examine books, papers, documents filed by individuals and corporations with and which are in the custody of government offices in the connection with government revenue collections operations for the sole purpose of asserting that all funds determined by the appropriate agencies. So that would be all. Thank you.
For the National Commission on Indigenous Peoples (NCIP), which means it is the agency of the national government of the Philippines that is responsible for protecting the rights of the indigenous peoples of the Philippines. So what are the other functions of the NCIP? Any persons who violates any of the provisions of this act, such as but not limited to unauthorized and unlawful intrusions upon any ancestral lands or domains as stated in Section 10, Chapter 3, or shall commit any of the prohibited acts mentioned in Section 21-24, Chapter 5, Section 33, Chapter 6 hereof, shall be punished by the customary laws of the IPs concerned. In the Section 10, the government shall take measures to prevent the non-IPs from taking advantage of the IPs' customs or lack of understanding of laws to secure ownership, possession of land belonging to said IPs. So in the Section 21, the equal protections and non-discrimination of IPs shall be extended to them the same employment, rights, opportunities, basic services, educational and other rights and privileges available to every member of the society. According to the state shall likewise ensure that the employment of any form of force or coercion against IP shall be dealt with by the law. So the state shall ensure that the fundamental human rights and freedoms as enshrined in the constitutions and relevant international instruments are guaranteed also to indigenous women. Toward this end, no provision shall be interpreted so as to result in the diminution of rights and privileges already recognized and accorded to women under existing laws of general application. In the Section 24, unlawful acts pertaining to employment, it shall be unlawful for any person, in order to discriminate against any IP, with respect to the terms and conditions of employment on account of their descent. Equal remuneration shall be paid IP and non-IP for work of equal value. And to all sections stated, this to ensure that the fundamental human rights and freedom can be guaranteed also to indigenous women, and the punishable act
will be implemented for those who didn't obey the laws and will be implemented and execute the applicable penalties such as imprisonment for 9 months to 12 years or the fines with the amount of 100,000 to 500,000 pesos or both fines such as both fine and imprisonment upon the discretion of the court. In addition, he shall be obliged to the IPs concerned whatever damage may have been suffered by the latter as a consequence of the unlawful activity. If this provided that it has no such penalties that shall be cruel, degrading, or inhuman punishment, neither a death penalty or excessive fines be imposed. This Provision Act shall be executed without prejudice to the right of any IPs to avail of the protection of existing laws. So the NCIP shall have the power and authority to promulgate rules and regulations concerning hearing and disposition of cases filed before it as well as those pertaining to its internal functions and such rules and regulation as may be necessary to carry out the purposes of this Act. To administer summons the parties to controversy issues subpoenas and requiring the attendance and testimony of witnesses or the production of such books, papers, contracts, records, agreements, and other documents of similar nature as may be material to a just determination of the matter under investigation or hearing conducted in pursuance of this Act. C is to hold any persons in contempt directly or indirectly and impose appropriate penalties therefore and to enjoin any or all acts involving or arising from any case pending before it which, if not restrained forthwith, may cause grave or irreparable damage to any of the parties to the cause or serious affect social or economic activities, which includes the programs being implemented of the NCIP for the sake of IPs, such as ancestral domains or land recognition, IP or cultural services, and culture appropriate, responsive, and gender-sensitive socio-economics and ecology development protection services, and assistance to ancestral domains, sustainable development and protection plan formulation, and so on. So this program will help to protect the indigenous peoples for their say to all their territories and assets, and especially their traditional homeland. So I'm Julie Rinco's report. Thank you.